Hi, everybody. Thanks for joining our webinar today on this July 1 day before our July 4th holiday weekend. My name is Dan Rudderow. I'm an attorney and I've been practicing law now for over 25 years. Our law firm represents the owners and managers of mobile home park communities as well as RV parks. Our firm prepares rental agreements and park rules for our clients. We handle evictions, and we also represent park owners in litigation cases throughout California. In our prior webinars, we usually talk about areas of the law that have been established for a period of time and for which we as attorneys working with our clients have experience with. Today is a little bit different. Today we're going to be giving you an overview of the new Mobile Home Residency Law Protection Act, and the part we're talking about actually goes into effect starting today on July 1. Since this law is brand new and only started today, it means that no one has had any experience yet with this law. So what we thought we would do is give everyone an overview as to what the Act provides and what the new program provides, and perhaps spot some issues that we see already that might be arising with this program so that we can help prepare everyone in the event our park owners or managers are contacted in connection with this new law. The webinar should last about 45 minutes long. During the webinar, you can submit written questions by clicking the Q&A. Time permitting, we will try to answer any of your questions at the end of the presentation. But if we don't get to your question, please, if you later think of a question or your question wasn't answered, feel free to email me with your questions at dan@rudderowlaw.com. Okay, we have a lot of information we wanted to share with you today, so let's get started. We're here to talk about the Mobile Home Residency Law Protection Act. And just by way of a background, the new law was enacted as part of the Health and Safety Code and not as part of the Mobile Home Residency Law. Apparently, it was made part of the Health and Safety Code because HCD has, generally speaking, a lot more general authority under health and safety than it does under the Mobile Home Residency Law, which is a civil code section governing the landlord-tenant relation. So I suppose the first thing this morning that's sort of funny is that we're here to talk about the Mobile Home Residency Law Protection Act, which is not found in the MRL. The other thing that has happened is I put in here last week on June 30th on the first bullet point, that's a typo, it should say just yesterday. Just yesterday, hot off the presses on June 30th, on an administrative basis, the administrative regulations for this new act were approved. So starting today on July 1, we have the new act, the statute, plus we have the adopted administrative regulations for that act, how that act is going to be carried out. We have that starting today as well. Basically, what the law does is it establishes the new Mobile Home Residency Law Protection Program, and HCD likes to use the initials MRLPP, and it establishes that program with HCD. HCD is going to be required to do several things under the program, but its focus is assisting and resolving and coordinating complaints that any homeowner may have relating to the MRL. Let me go on to the next slide here. There's many different things that the Act provides, but I wanted to give you all a general overview of what conceptually they're doing on this law. What they're saying is that starting today, any homeowners in your mobile home park may submit complaints to HCD that relate to alleged violations of the Mobile Home Residency Law. What they've done in the law is they've basically established two different processes, or screening processes. They've created an initial review process, and they've also, after that, created a secondary review process. Under the initial review process, HCD is going to make attempts to weed out the complaints, and during that initial process, they're going to try to refer the complaints to other more appropriate government agencies for handling. And then they're going to select a few or many, and we'll see how this works out, for the secondary review process. And it's under the secondary review process that HCD may ask the park owner or management for documents. It's under the secondary review process that HCD may require that the park and the homeowner engage in negotiation or mediation process. And it's under the secondary review process that finally at the end, HCD may refer the homeowner to a nonprofit qualified legal services provider, i.e. an attorney, that is going to be paid for by HCD. So that gives you kind of an overview of what we're going to be talking about today. As many of you know, starting last year on January 1, 2019, the Act required HCD assess an annual registration fee of $10 for each permitted mobile home lot. And by my calculation, I think we have about 393,000 spaces in California. Multiplied by $10, I would think that's about $3.9 million per year. This program is supposed to expire on January 1, 2024. So we're talking about collecting this 3.9 million during 2019, 2020, 2021, 2022, and 2023. So over the course of 5 years, I think it's probably estimated that they'll raise or collect around $19.5 million. And as many of you know, if you do it timely, the $10 charge can be passed on to the homeowners for them to pay the $10. Let's go on to the next slide. So let's get started. And let's talk about, in terms of identifying possible issues that may come up, what I wanted to do was start at the beginning and start with the first step, which is who exactly may file a complaint against the park. The Health and Safety Code section refers to homeowner or complaining party, and it actually says that it defines homeowner as the same definition that you would find in the MRL, which is basically a homeowner is defined as a person who has a tenancy under a rental agreement with the park. But we did notice, as these regulations were finally approved last night or yesterday on June 30th, we did notice that the regulations start using different terms such as complainant, which they defined as mobile home or manufactured homeowner or the designee acting on behalf of the homeowner. And if you see my first bullet there, when I have the word homeowner separated, home and owner, that's not actually my typo this time. This is actually the way it reads in the regulation. And I think that's probably a typo. It gets a little confusing, as we know. The MRL makes this a little confusing. We have the word homeowner, who is the person with a tenancy in the park, but that may not necessarily be the registered owner of the home. So you can have a homeowner who's essentially the tenant, someone who has a tenancy with the park who signed the rental agreement. However, that mobile home, the registered owner of that mobile home may be anyone, your aunt, your uncle who lives in Utah or Florida. They're not necessarily the same thing. I think this typo here with the resolution is a little unfortunate because it makes it seem like maybe the registered owner could lodge complaints. And I think that's probably a typo. Everything else that we've seen on all of the materials, the statute and the resolution, I think the purpose of all of this is just to allow the homeowner who has a tenancy in the park to file a complaint. Now, the resolutions say that the complaint can be filed by the homeowner or the homeowner's designee. So we are going to, having said that only the homeowner can file a complaint, I think we are going to perhaps get into issues of who is this person that's submitting the complaint? Are they the homeowner, or are they the homeowner's designee? And if they are the designee, then they have to give this information to prove that they are a designee to HCD, essentially saying I'm authorized to speak on behalf of the homeowner. As all of us in the mobile home park community industry know, we've had this experience before where homeowners pay the rent, and now there's a new law that maybe homeowners designee can pay the rent on their behalf if they have the right paperwork. This is somewhat similar in the sense that the homeowner's designee could file the complaint on behalf of the homeowner as long as they're proving who they are to HCD. But as the last bullet point on this slide I say is, are we going to have issues with companions or caregivers who are filing the complaints with HCD? If a park owner is eventually aware that there's been a complaint filed by the caregiver who doesn't necessarily have a tenancy, and is not the homeowner, that might be something that a park owner wants to communicate back to HCD and explain that the complaint that HCD received was from a caregiver or a companion or a guest. And unless that companion or guest or caregiver went through the right channels of showing their authorized designee, I think the thinking is that that would be important to tell HCD so that HCD can get back to the caregiver and say, yes, you either give me a designee form or I can't help you out, because this program is not designed to review complaints by caregivers. It's only complaints submitted by homeowners. So again, to recap, here the homeowner is submitting the complaint, and the regulations say the complaint can be any oral or written communication transmitted to HCD related to an MRL violation. The way they have this set up right now is that by statute and regulation, the homeowner can submit the complaint to HCD pretty much any way they want, meaning they could do it verbally, by telephone, by email, or by mailing a letter. My sources tell me that HCD has or will invest a lot of money in IT in setting up this program. So presumably, I would anticipate HCD trying to steer complaints to be done all by email. There is also in the regulations, however, the regulations talk about a defined term they call a department communication, which we'll see in this PowerPoint. It says that department communication is where HCD communicates back to the homeowner and should be doing so in the same medium that the complaint was received. So suggesting that if the homeowner submitted a complaint verbally, that the department should respond with a department communication verbally, and if emailed, then the response should be email. So it's a little confusing here, but to recap, the homeowner may submit a complaint any way they like, and there is a regulation that HCD will communicate back in the same way. But it also looks like HCD will actually encourage people to probably use email, and HCD has what they are saying here, a designated complaint form, which I think we're going to arise out of the resolution, and we don't have the regulations, and we don't have the regulations. We didn't have the regulations approved until yesterday, so we don't yet have that form as far as I'm aware, so we could show it to you today. But I think that's where HCD is going to go. I think they're going to have the law that people can file complaints any way they like, but I think eventually they're going to be trying to steer people to communicate with them via email and use their complaint form that they're going to eventually make available on their website. So after that homeowner or the homeowner's designee submits his or her complaint, HCD is supposed to promptly send an acknowledgement letter to the homeowner confirming receipt of the complaint. It's important to understand, I think, that this first act by HCD, this acknowledgement letter, is going to be sent just to the homeowner and not the park owner. People I've talked with have said that, number one, park owners, of course, were not thrilled with any of this new law, but there were some park owners that were very resistant, that they didn't even want to get this acknowledgement letter because then they would have to incur resources to investigate it. And the thought was, if in the initial review process, a lot of the complaints are going to be handled where the HOA is just referred to another department and it stops there, then it may not even need to get the park owner's attention. Whether that's true or not, I'm just giving you some background information of what I heard. So in any event, whether that is a true story or for better or for worse, the statute and the regulations are saying that when the complaint is filed, HCD is going to send its acknowledgement letter simply to the homeowner. So presumably the park owner at that point is not going to know that a complaint has been filed. What HCD is going to try to do, because this will be the initial period of review, is they will try to put in that acknowledgement letter, provisions of the MRL that are applicable, and possibly try to refer this homeowner to a different department. And in this last bullet point, this is somewhat what their complaint form will ask the homeowner to fill out. When HCD now conducts its initial review, there's a couple things they're going to be looking at. Number one, they are going to be looking at whether or not this complaint even arises or is connected with the MRL. If it's something that really doesn't relate to the MRL, they may, tell the homeowner this is not the right place for their complaint. Also, they have by statute said that they are not going to process any complaints that are more than 18 months old. I don't think that that's going to come up very often. I would think that homeowners who have a gripe are not going to sit for 18 months and then file a complaint with HCD, but it's the law and it's one of the things we could check off of our list. For complaints that most likely are not going to be 18 months old, the complaint can be handled in a variety of ways. It can be referred to MAC, the Mobile Home Assistance Center. It can be referred to the appropriate local enforcement agency. HCD could determine that this is one of those serious violations that should be forwarded for secondary review, or it could even close the file and tell the homeowner why they're closing the file. In terms of the Mobile Home Assistance Center, it's my understanding that eventually, if a complaint doesn't go through this entire process, they will probably not leave the homeowner completely hanging with a "sorry, we can't help you." Probably the Mobile Home Assistance Center will be the catch-all, meaning complaints that can't be handled through this program in the end probably will end up with the Mobile Home Assistance Center. And the Mobile Home Assistance Center basically will be doing the same thing this program does, but that's sort of where they kind of envision that the complaints will perhaps end up in the end, if not otherwise handled in a different way. In terms of referring it to another agency, some of this is very straightforward. If the homeowner filed a complaint with HCD and said, "I'm being discriminated against because of my race or my gender," a discrimination complaint HCD intends to forward to the Department of Fair Employment and Housing, or DFEH, for further handling. If it's something like maybe the complaint is an assault and battery, something criminal, I think HCD is looking at, referring that person to their local law enforcement agency, the sheriff or the police. One of the complaints that I think we should anticipate that are going to be submitted to our park managers under this program is the complaint that the homeowner says that the rent is too high. And it's my understanding that the complaints that talk about the amount of rent as being somehow wrong, those complaints too may be referred elsewhere. They may be referred to a local rent control board, city, or county. I think also the amount of rent that's being charged, the gripe may be that it violates one of our COVID unlawful detainer moratoriums. And I could see HCD maybe referring them to the moratorium. I can also see that if a homeowner is saying that their rent was increased, but they didn't receive the requisite 90-day notice to increase their rent, that would arise under the MRL and would be something that would be processed during this program, through this program. There is always going to be a combination of complaints, like hypothetically, a homeowner says that their rent is too high given all the sewage problems at the park. HCD may look at that and say that the rent being too high is something they will not get involved in, but they will get involved in the mobile home residency law and responsibilities of the park to the park owner to maintain the park. And because this complaint dealt also about inadequate sewage service or a sewage problem, that's something that a complaint about the rent being too high because the sewage system doesn't work, that might be something that HCD does take under its wing or keep in this program. There could be other things, there might be a homeowner's complaint could relate to a land use issue that HCD could refer that land use issue to a local county planning department. As many of you know, HCD has jurisdiction over parks unless the local city or county has assumed that jurisdiction on some health and safety issues. HCD may refer the complaint out to the city if it involved something involving that city's local jurisdiction that it took over from HCD. So that is going to be what they're intended to do, weed out most. I don't know if it's going to be 70 or 80%, but this is going to be a key part of the whole program, that the initial review of the complaint is weeding them all out to other agencies, rather than have those complaints go on to the next level, the secondary review. Secondary review, as I said earlier at the beginning, that can involve several different things can happen during the secondary review. During secondary review, HCD can ask for information and documents. During secondary review, it can ask the parties to engage in a resolution / mediation / negotiation process. And then finally, it can refer the homeowner to a nonprofit legal services provider. So taking each one at a time, the first of that is that HCD may request information from the complainant, from the homeowner. If the homeowner doesn't get back to HCD with the information, HCD has the option of closing the file and even reopening the file later, as long as the claim hasn't gotten more than 18 months old. HCD may also request documents from the park manager. And basically what the system here is that they will make this request and the park will have 15 business days to comply and produce the documents, and can ask for an extension on that 15 days. The documents are supposed to be, that are produced by the park are not supposed to be provided to anyone other than the complainant, HCD, the law enforcement agency, and maybe even their attorney. The regulations, interestingly, say that the documents will not be subject to a California Public Records Act. One of the several thoughts on this is HCD under the statute is expressly prohibited under the Act to arbitrate, mediate, negotiate, or give legal advice. But the statute goes on to say that HCD may provide information to the parties. So I think what we're expecting is that the park may produce documents to HCD, and HCD will give its views or its opinions as to what the result of their document review was once they get the documents from the park. One of the issues that is obviously going to come up is whether or not the park should comply, whether it should produce the documents. The park management may refuse to provide the documents and assert a privilege. Under the rules of evidence in court, generally two sides need to produce documents unless one of the attorneys says that under the rules of evidence the document should not be produced because it's subject to a legal privilege or grounds for why the document doesn't need to be produced. The statute goes on to say that the park can either produce the documents or it can produce a privilege log indicating which documents are not being turned over. And if park management fails to comply with this request of either producing the documents or producing a privilege log, HCD will issue a citation of $250 for each failure to comply. The park can then appeal the citation by requesting an informal hearing. The things to keep in mind is I think that keeping a positive thought on this, I think my information is that many people at HCD expect the document request process to go fairly smoothly, meaning HCD may ask only for that homeowner's rental agreement or may ask the park to produce a copy of the park rules, something that perhaps the park is willing to turn over. HCD has on their website an information bulletin 2018-03 that says that the park may be asked to turn over the homeowner's lease, the park rules, or quote, any other relevant written documents applicable to the complaint. And it's that phrase, any other relevant written documents, which may be an issue. It will depend, of course. We don't know exactly what will happen. But obviously, if the park owner gets a request for documents from HCD that says, give me copies of everyone else's leases in the park or give me copies of the rent roll, then that's obviously something that has to be looked at. Even when you're producing the homeowner's rental agreement that filed the complaint, there might be information on there you want redacted. So it's important that, I think on the one hand, it's contemplated that they'll ask for documents that are not an issue and the park will produce them, but we don't know. And to the extent that HCD asks for other types of documents, then the park owner is going to want to probably consult with counsel and go through these 5 steps that I've put here on the bullet point, which is, evaluate what documents they want, to determine whether the park even has those documents. Determine whether or not there's any privileges upon which you can rely not to produce the documents. Prepare a privilege log, and then determine which documents you are going to produce or not produce, and then run the risk or not run the risk of a $250 per violation citation. So the other thing that HCD can do in the secondary review process, other than ask the park to produce documents, is it can ask the parties to engage in what they call the resolution process, which is, of course, a cute name, resolution process. It sounds very positive that the park owner and the resident will engage in essentially a mediation without a mediator to try to resolve it. And so basically, as I've said here, after gathering all the relevant documents, HCD will initiate this resolution or negotiation process by sending a department communication. Again, that just means communicating with the parties the way they were communicating with the parties, whether it be email or written letter or telephone, to the complainant and homeowner and the park management specifying, what are the violations, notifying the parties of their obligation to negotiate in good faith over the course of 25 calendar days, so almost a month, that the parties can communicate in person, by telephone, email, or standard mail, that the parties may have representatives assisting them, and that only good faith efforts, not actual resolution, are required. So similarly to any mediation or MRL, mandatory settlement conference, MSC, that you've been to, they can't twist your arm to force you to settle. They simply set up a process to, quote, force you to participate. But whether or not you give up anything during the negotiations or decide not to and not reach an agreement is up to you. Again, I put down here what I said before about HCD not arbitrating and mediating. So HCD is not going to act as a mediator during these 25 days. It's telling the two parties to go off and, try to resolve it on their own. I suppose it's nice that this statute does not require the negotiation to be in person, since we do have COVID-19. Some statutes years ago under other areas of the law did require face-to-face meetings and said you couldn't do this by telephone, just like mediation sometimes require people to attend and don't allow them to attend by phone. But here, this communication doesn't have to be done face-to-face. It can be done by telephone or email. Obviously, there's some things you should think about when you're negotiating with a homeowner. Should be very careful about putting anything in writing, because that writing could come back to haunt you. It could be used to something against you in a court of law later if somehow this complaint is not resolved through this program. You can consider whether or not to have your lawyer do the negotiation for you. And of course, I think you all are probably aware, be careful what you agree upon, both in terms of giving one concession to one homeowner, and then other people in the park will find out and they'll want either the same concession, or they'll be annoyed that you gave special treatment to the one who complained. Again, you don't have to agree to anything. You only have to engage in the good faith discussions. It's interesting, the statute seems to say that if you didn't produce documents, you could get sanctioned with or issued a money fine of the $250. But if you just refuse to even engage in the good faith discussions, there doesn't seem to be a similar sanction for that. The downside, I suppose, to the park owner is if they don't take the opportunity to try to engage in this process of trying to work it out with the homeowner, this homeowner may be given counsel paid for by HCD later on in the process, and perhaps the dispute with the homeowner will be more difficult to resolve if the homeowner is not paying his attorney, has an attorney, but is not responsible for paying his or her attorney's fees. So it's an opportunity to resolve it, and not quite clear what the consequences are if you don't participate. In any event, after the 25 calendar days has ended, the law provides that HCD will send an inquiry basically asking the parties, hey, what happened? did you guys resolve it? And tells you here what you need to do in terms of telling HCD that you resolved it. I put here my great IT person, Megan. She puts all the cartoons on here, which I love, just to keep us all laughing a little bit and keep us awake. She put case closed. I love that, but it's not necessarily case is going to be closed. If obviously the homeowner and the park come to HCD and say we worked it out, then HCD will close their case. And it's interesting in the second bullet point, if no timely response from either side, I suppose HCD will just be hopeful and assume that it got resolved and close its file as well. But if the homeowner or the park indicate that the matter was not resolved, then the complaint can be referred to a nonprofit legal service provider, and another department communication will be issued to the parties notifying them of that. So one last thing I wanted to say on this point was that it's also possible, it seems, reading the regulations and the new act, that it could be that they don't automatically send it to the nonprofit legal service provider. They could decide to retain the complaint for a variety of reasons that I've spelled out here on these bullet points. And so it will, I suppose it's not necessarily true that if you don't resolve it in the 25 days, it automatically is going to go to giving the file to a legal service provider. It may not, but that's kind of the rub. So what I want to talk to you about, I wanted to put the next two slides over here in front of you separately, because the law is sort of confusing the way it has different provisions in different areas. But basically what I wanted to just point out with these two slides is that what they're trying to do is, with all complaints, obviously, that come through the door will get an initial review. But the criteria for which of those complaints make it to the secondary review are basically the two criteria they look at. Is they say they're going to look at those complaints that are the most severe, and they're going to look at the geographic location of where those complaints come from. This is the statute that we thought we would quote with regard to looking at the severity of the complaints to determine which ones go on for secondary review. This is the language, that the department shall use good faith efforts to select the most severe, deleterious, and materially and economically impactful alleged violations of the mobile home residency law. So on the one hand, they're going to look at severity and this language here in selecting the complaints. The other component is the geographic location. They're going to divide California into 5 geographic regions, and then they're going to try to draw an equal number or select an equal number of complaints from each region. I think that each region is going to have the same number, basically, of mobile home park spaces. And I think the thought process on this is that they want to select complaints that would be fair and representative of the entire state of California. So they didn't want a situation where maybe you have 1 million mobile home parks in the city of Los Angeles, and maybe just hypothetically you have 2 mobile home parks in the city of Hemet, and and they didn't want to just constantly be processing and selecting for secondary review just based on the number of complaints they got from LA. Just have it all be LA who got their complaint sent on to secondary review and no one from Hemet. So I think the idea is divide California into 5 areas, and the 5 areas will have the same number of spaces in each of the 5 regions, and then select complaints equally, maybe 10 complaints out of each of the 5 regions as a way of spreading it around, or making it fair, I suppose, that you're selecting complaints from all over California. So after, and on that geographic diversity, the previous slide, I don't exactly, I'm not clear how, I don't have the geographic regions, and I heard from someone that maybe 2 of the geographic regions would be managed by HCD in Sacramento, and 3 of them would be managed by Riverside, but I still don't have any information on that, confirming that yet. So after exhausting all internal methods to resolve the complaint, then finally the last stage is HCD referring the complaint to a qualified nonprofit legal service provider. This is my understanding that legal service providers can go through the normal public contract process of getting a contract with a public entity and go through the application process and getting selected. This slide here talks about how the legal service provider can determine which cases they're going to take, how are they going to handle them, and so forth and so on. Some other points about the legal services provider: they must be nonprofit, they must have experience handling MRL complaints or general landlord-tenant matters. So I don't know how that's going to work if we're going to find that these legal service providers have no experience with the MRL. They just had experience with general landlord-tenant matters. They must have sufficient staff and financial ability to represent the homeowner. They have to agree in their contract to indemnify HCD. They're not allowed to charge any fees to the homeowner, so I suppose it's not going to be a situation, I suppose, where the provider can take HCD's money, represent the homeowner, and then say to the homeowner, oh, do you want to pay for a little bit more for us to finish representing you, with this statute saying that. Each contract will be for 3 years and can be extended for 1 year. The department's going to ask for proposals. The amount of funding will be specified in each contract. I think us lawyers are interested in other parts of the Act that say that a lot of this is not subject to the Public Records Act, and see how that works out with obtaining copies of their contract. HCD has the discretion to reopen a closed file and start the process all over again. At the end of all this, I think it's the first date is correct at the top, 2023. The bottom date should be 2024. So on January 1st, 2023, HCD will submit a report to the legislature outlining how this program went. And then this program is set to expire on January 1, 2024. So we've got the rest of 2020 and then year 1, 2, 3. So we've got 3.5 years with this program of going through this process if the program is not renewed. I think that's our last slide, and I think we're doing well on time. We're about 12:43, 44. So let me kind of go over some of the questions that we'll see if we can't get answered for you. Does this apply to RV parks as well? It looks like it's going to, but it does. In a way it does, in a way it doesn't. I'm thinking that it will probably not apply to RV parks because a true RV park is not governed by the MRL. It's governed by the Recreational Vehicle Act. I say that just because I'm always hedging that maybe it could be applied to RV parks because the informational bulletin that is on their website says to mobile home and special occupancy parks. So my thinking is that this is going to apply just to mobile home parks, not to RV parks. But there's a chance it could be applied to RV parks if that's the way they want to go with applying this to other types of parks. Another question is, if there is no timely response, will notification be sent to the park owner that the case is closed? It looks like the answer is yes. The department will close the complaint and provide a department communication to both parties at that point, notifying both parties that the complaint has been closed. Let's see, and then one last question that we got. We see Gizmo, Golden State Manufactured Home Owners League communicating with residents to send their complaints there first. Are they trying to insert themselves as the complaining party? Obviously, that's a good question. I suppose that could be the case. It'll be on an individual basis. At this point, the complainant has to be the homeowner or its designee. I suppose we can see situations where the homeowner fills out the proper paperwork to make their designee a representative of Gizmo. I think that was the last question that we had.
Let's see if any other.
We're just checking the computer to see if we have any other questions that popped up since we got these.
Nope, we covered them all.
Looks like we covered them all. Well, everyone, thank you so much for joining our webinar. I hope you found it informative. If you have any other questions, give me a call or send me an email. Everyone stay safe this July 4th. And please give me your feedback on the polling questions, especially if this time of 12 o'clock doesn't work for you. We've been thinking about doing them at 3:30 in the afternoon or perhaps 11 o'clock in the morning. Last time people said 12 o'clock was fine, but if this doesn't work for you and your employees, please give us that feedback and maybe we'll switch up the times next time. So everyone have a great, safe July 4th holiday. Thanks. Bye-bye.